Thank you very much, Bennett. Council will do introductions and any opening matters. Plaintiff counsel, please do introductions and any opening matters.
Yes, Your Honor. My name is Hanan Yousuf, and I'll be the plaintiff attorney representing Ethel Marks on behalf of her daughter, Jessica Marks, in today's trial. My second chair is Mr. Avery Rose, and he will be handling all of the technology in today's round.
Thank you. Good to see you. Defense counsel.
Your Honor, members of the jury, my name is Lucy Bolter, and today I represent Sonny's Rooftop Bar. Today, I'll be joined by my co-counsel, Lauren Nonemacher.
Good afternoon, Your Honor.
Good afternoon.
And we do have a few preliminary matters.
Go ahead.
We would like to draw the court's attention to the evidentiary rulings on pages 7 and 8 of the electronic copy of the case, specifically numbers 11 and 12. These are the rules. 11 would be exhibits 1, 22, and 23 are pre-admitted and may be used at any time. And number 12 is Stevie Rager, Greg Grimes, and Frankfurt Johnson are all unavailable under FRE 804A. And then also the stipulations found on page 8 of the electronic copy of the case. Specifically number 21, which just says that exhibits 26 and 27 are authentic. And with that, Your Honor, the defense is ready to proceed with opening statements.
Your Honor, the plaintiff also has a few pretrial matters we'd like to address.
Go ahead.
May we assume that all the exhibits from 1 through 27 are pre-marked as such for identification purposes throughout trial?
Yes, we'll observe the pre-markings.
We asked to invoke Rule 603, the constructive swearing in of all witnesses.
All witnesses are sworn in.
We also asked to invoke Rule 615, the constructive sequestration of witnesses, barring party representatives.
Witnesses are sequestered.
And given the virtual nature of this trial, how would you like connectivity issues to be handled in your courtroom, Your Honor?
What do you have in mind specifically? Obviously, if there's any issue that's technical, we'll ask the timekeepers to stop time till the technical issue is resolved, and we'll be patient to allow that to happen. What other issues are you interested in discussing?
Yes, Your Honor. At any point throughout this trial, if you can't see or hear me properly, I feel free to interrupt me and let me know.
Yes, we'll ask people if they need to work on any technical issue, we'll mention it. But right now I can hear both plaintiff and defense counsel quite adequately.
And court, pursuant to rule number 9 of the local procedural rules for the online tournament, we would just like to confirm, pursuant to D3, that direct examinations for this online tournament are 9 minutes instead of 8.
I don't know. Just so long as we all agree. Defense counsel?
I have no objection to that, Your Honor.
No, I'm fine with that. Just so it's fair and equal.
And just to be clear, we wanted to ask if opposing counsel had a timing person on standby.
Yes, we have my second chair who will be timing as well.
Okay. And with that, Your Honor, I'm sorry.
Well, plaintiff counsel, are you having a timing difficulty of some sort?
Yes, Your Honor. That's why we needed to confirm that.
Okay. Well, if somebody runs out of time, timekeeper can come on screen to make that clear. If you have time cards, you can show time cards. Otherwise, please put the time information in the chat.
Yes, Your Honor. And with that, the plaintiff is ready to proceed with opening statements.
And defense counsel, do you have any more?
No, Your Honor.
Okay, we'll proceed with opening statements. I'd ask everybody to switch to speaker view. And in speaker view, plaintiff counsel, you're opening.
May it please the court, Your Honor, opposing counsel, and members of the jury. March 24th of 2019, Jessica Marks went out with her best friend Morgan Levin to have some fun over spring break. She stepped into Sunny's rooftop bar at around 9 p.m., but it was barely 3 hours later when she was pronounced dead. It was barely 3 hours later when her body was found in a car upside down at the bottom of a ravine off a highway. It was barely 3 hours later when her blood alcohol content was recorded to be 2 times the legal limit. Good afternoon, members of the jury. My name is Yousuf, and today I proudly represent the plaintiff Ethel Marks on behalf of her daughter Jessica Marks in today's case of Ethel Marks versus Sunny's Rooftop Bar. Now, as the plaintiff today, we proudly hold the burden of proof to prove our case by a preponderance of the evidence. That just means that we have to tip the scales of justice ever so slightly in our favor to show that it was more likely than not that the defendant is responsible for the death of Jessica Marks. Now, today we brought forth a case of wrongful death using the Dram Shop Act. This is the California law that says that the defendant is responsible for Jessica Marks' death if 1, the defendant served alcohol to Jessica as a minor. 2, Jessica was obviously intoxicated at the time. And 3, the defendant Sunny's bar was the substantial cause of Jessica Marks' death. Now, for this first element, you don't have to worry about it. Both sides already agree that at the time of March 24th, 2019, Jessica Marks was a minor under the age of 21. So I just want you to focus on elements 2 and elements 3. So for the second element, the judge is going to give you a set of jury instructions by the end of this trial. And you'll see on those jury instructions a list of things to see as signs for someone who is obviously intoxicated. On this list, you'll see bloodshot eyes, slurred speech, and stumbling. Now, I want you to pay attention to these signs and look out for them in today's trial. As members of the jury, you'll see today that on March 24th, all the signs were there. You'll hear how the defendant served Jessica Marks drink after drink after drink, even after seeing those signs. They saw her stumbling around with bloodshot eyes, and they heard her slurring speech, but they kept pouring those drinks. Now, for this third element, members of the jury, we're gonna have to make some connections. We don't have to prove that the defendant was the only factor in Jessica Marks' death, but only a substantial factor. It was more likely than not that the defendant caused her death. And for that, you're gonna hear today how the defendant ignored the signs of Jessica Marks being obviously intoxicated and kept serving those drinks. And the second they kept serving those drinks was the second Jessica Marks anymore. Her reasoning was disabled, and she was just a 19-year-old drunk girl. A drunk girl who was drunk because the defendant served her. And they let her walk out of their bar. It was only minutes after she left their bar. It was only minutes later that her body was found in the bottom of a ditch off a highway that she swerved off of. Members of the jury, the evidence will show today that you must find the defendant liable. Thank you.
Thank you, counsel. Defense counsel, if you'd come on screen and deliver your opening.
Yes, Your Honor. May it please the court, counsel, members of the jury. Sunny's rooftop bar couldn't stop, but they couldn't see. And they couldn't see what Jessica Marks hid from them. On Sunday, March 24th, Sunny Meadow woke up, got dressed in her usual work clothes, and headed to the bar that she had owned for many years, Sunny's Rooftop. There was a customer there that night, Jessica Marks, but looked like she was just trying to enjoy a good time with a friend. But what my client didn't know was that Jessica Marks was really hiding a lot. My name is Lucy Bolter, and today I represent Sunny's Rooftop and their owner, Sunny Mehta. I'd like to tell you about her. She's a young and up-and-coming entrepreneur. She's worked at several businesses throughout her career. In 2019, one of her businesses was Sunny's Rooftop, an upscale restaurant here in California with a small bar but a large rooftop eating area. She's a responsible business owner that follows all training and cares greatly about the safety of her customers. Now, the plaintiff in this case has sued my client for wrongful death of Jessica Marks. They've accused her of somehow being responsible for that death. But the truth is, Jessica Marks made many poor decisions that night. And sadly, her death was caused by her own choices. Judge McGinnis is going to tell you that because the plaintiff is the one that's made these accusations, they carry what is called the burden of proof. That means that it's their job to prove to you by the greater weight of the evidence that my client actually did what they've accused her of today. I can tell you right now that they will not meet this burden. They can't. There is no proof. There is no evidence because my client isn't responsible for the choices that Jessica Marks made and the things that she hid that night. You'll actually get to meet Sunny Mehta yourself today. She'll take the stand and testify about what really happened that night. You'll learn that she had never met Jessica Marks before, but when she and her friend came in, Sunny Mehta did the same thing she's done every day she's owned that bar. She checked their IDs, and then she began to wait on them. But pay close attention as you learn today that they lied about their age. They gave her fake IDs. They went to a lot of trouble to hide the fact that they weren't even old enough to drink alcohol. Sunny's Rooftop works hard to protect customers. They're trained to watch signs of intoxication. They have a strict policy to stop serving alcohol to customers that show obvious signs of impairment. They call Ubers. They even take away keys. They care about safety. In fact, Jessica's friend Morgan wasn't even allowed to drive home that night. My client made sure of it. But Jessica Marks showed no signs of being drunk. She hid the signs of her intoxication, and today you'll learn just how successful she is at that. Sunny's Rooftop bar couldn't see what was intentionally hid from them, and they can't be responsible for Jessica Marks' choices that night, no matter how tragic they are. So at the end of this trial, I'll ask you to do the only thing justice demands. I'll ask that you find them not liable. Thank you.
Thank you, counsel. We're now ready to hear the first witness. I suggest we all go to gallery view, and plaintiff, you may call your first witness.
Yes, Your Honor. At this time, the plaintiff would like to call Morgan Levin to the stand.
Levin is called.
May I proceed?
You may proceed.
Introduce yourself to the court.
Good afternoon. I'm Morgan Levin.
And what do you do for a living, Miss Levin?
So I'm actually still a student. I go to UCLA out on the West Coast, and I'm a rising senior there.
Do you know why you're here today?
I do. A few years ago, my best friend, Jessica Marks, she was visiting me over spring break, and we went out together one night, and she got in an accident. So I guess I'm here to tell you what I know.
I'm so sorry to hear about that, Miss Levin. I just want to talk a little bit about Jessica. How did you know her?
Well, Jess and I met in junior high. We had the exact same birthday, so month, day, year, everything, and we were we were basically inseparable. I mean, we do joint birthday parties every single year. It was kind of like having a sister.
Where were you and Jessica the night of March 24th?
Well, like I said, she was visiting me for spring break, and we went out to a bar in Malibu. It was called Sunny's Rooftop Bar.
Were you and Jessica old enough to go to this bar?
No, I mean, it was spring break of freshman year. You know, we were both 19.
Have you and Jessica had drinks before?
Yeah, we would have a few drinks every now and then, but we weren't, big drinkers.
Did you have a lot to drink on March 24th as well?
I mean, I didn't. No, I had maybe 3, but I mean, as the night went on, Jess just kept drinking. She didn't even really sound like herself by the end of the night. That's how drunk she was.
I want to talk about how Jessica was acting after she had drunk alcohol. Could you tell us Jessica's physical demeanor at the beginning of the night?
At the beginning of the night, we met at her Airbnb, and everything was totally fine. I mean, she was just like herself. It was Jess. So, I mean, she even posted a video on her Instagram before we got to the bar. Everything was fine.
And did this change at any point throughout the night?
Yeah. I mean, like I said, she just drank and drank. Nothing she was saying was making any sense. She was slurring her words, and every time she stood up and she tried to walk, she was just wobbling, and I thought she was gonna fall over. And then one time she actually did fall down the step.
Now, you mentioned a video that Jessica took at the beginning of that night. If I showed you this video, would you be able to recognize it?
Yeah.
Miss Levin, what you're looking at is Exhibit 6. Do you recognize it? How do you recognize it?
That's the video we were just talking about. That's Jess. That's Jess on screen. So I was at her Airbnb when she took it that night.
Do you know around what time you took this video?
8:15 or so.
Your Honor, permission to enter Exhibit 6 into evidence?
Counsel, is there any objection?
No, Your Honor.
The exhibit is received.
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. Go hard or go home. Not ready to go home.
Now, Miss Levin, did Jessica make any other videos that night on March 24th?
There was another one on her Instagram that I took while we were at Sunny's that night, like 11 or so, near the end of the night.
And if I showed you this video, would you be able to recognize it?
Yeah.
Your Honor, we're now displaying Exhibit 10 outside the presence of the jury. Has Exhibit 10 been changed or modified in any way?
Not that I can see, no.
Your Honor, at this time, the plaintiff moves to enter Exhibit 10 into evidence.
Counsel, is there any objection?
No, Your Honor.
The exhibit is received.
We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Now, looking looking at these two videos side by side and personally seeing the way Jessica was acting that night, how would you describe the level of sobriety in that first video?
Sure. I mean, that's just Jess. That's what she looked like when she was totally sober. She hadn't drunk anything at all.
And what about for that second video you just saw?
And that's when she was just drinking and drinking. I mean, she looks like she's drunk. She was slurring her words. And I mean, she doesn't even really make any sense. We weren't even in Hollywood when we took that video.
Did anyone else see Jessica in this state?
Well, I know Sunny Mehta did, you know, the bar owner.
Objection, lack of personal knowledge.
Response, Your Honor?
Well, counsel, please explain the lack of personal knowledge. Please explain your objection, counsel.
Yes, Your Honor. To say that my client saw something is, this witness is unable to testify about that, as only my client can testify about what she specifically saw that night. Therefore, this would be speculative and lack of personal knowledge.
Plaintiff counsel.
Yes, Your Honor. Pursuant to Rule 602, this is based on this witness's personal knowledge, seeing Sunny Mehta there when this incident happened, when Jessica Marks stumbled down the stairs. Sunny even commented on the event. Therefore, this witness is using their rationally based perception pursuant to Rule 701 to come to this lay witness opinion.
Well, counsel, the real problem is the phrasing of the question. This witness can say what this witness saw, but does not know what exactly Sunny Mehta saw. So in terms of phrasing of the question, I'm going to sustain the objection. You'll have to rephrase the question.
Yes, Your Honor.
Now, Ms. Levin, was Jessica Marks hiding these symptoms?
Objection, lack of personal knowledge and speculation.
Response, Your Honor?
Yes, counsel.
This witness would just testify as to whether Jessica Marks was physically showing the symptoms she described earlier from Exhibit 6 and Exhibit 10.
Defense counsel.
Yes, Your Honor. To say that Jessica was hiding something, that's speculating about her motive, what she was thinking in her head. That's not talking about anything specific with her actions.
I'm going to sustain the objection.
Yes, Your Honor.
Ms. Levin, was Jessica acting the way that she did in Exhibit 10 at any point throughout the night?
In most of the night, yeah, there's one specific time that I remember. So we were upstairs on the rooftop that night. And if you wanted to go to the bathroom at Sunny's, you had to walk all the way down the stairs into the indoor space. And like I said earlier, every time Jess stood up, she was wobbling. And so when we went down the stairs, she fell right into Sunny Mehta. And Sunny said, "Whoa, Frankfurt, we might need to cut this one off."
Did the defendant cut Jessica Marks's alcohol off like they said they would?
No, they just kept serving us drinks.
Now, you mentioned Frankfurt in that statement the defendant made. Do you know who Frankfurt is?
He was another bartender that night. Jess kept flirting with him, going inside and getting free drinks, that kind of thing.
And did Frankfurt give those drinks to Jessica?
Yeah.
Now, what happened after? Now, I want to talk about when Jessica was leaving the bar. Did the defendant say anything to her then?
Yeah, that one was Sunny again. We went down the stairs again into the bar, and we were going to get our last round. And we walk up to the bar, and Sunny points at Jess, and she looked at me, and she said, "Whoa, I hope this one isn't driving." And then he poured her a shot.
And how was Jessica acting when she was getting ready to go home?
I mean, she was acting pretty strange. we drove there together, but I ordered an Uber at the end of the night because I didn't want to get in the car with Jess, and I didn't think she was safe to drive. So I told her that she shouldn't get in the car, and I told her she should come with me, but she wouldn't listen. And she started giving herself like a fake sobriety test. I wish I convinced her. I wish I convinced her to get in the Uber with me, but she wouldn't come.
No further questions, Your Honor.
Counsel, you may cross-examine.
Yes, Your Honor. Before I begin, Ms. Levin, I just want to make sure that you can hear me okay.
Yeah.
Now, I want to start where you just talked about Jessica allegedly falling down the stairs. Did I understand that correctly?
Yeah, you did.
Now, Ms. Levin, the truth is that you had been drinking a lot of alcohol that evening.
I had 3 drinks, yeah.
You had wine,
Yeah, I had a glass.
you had beer,
I did.
you had shots of hard liquor.
I had a shot at the end of the night, that's right.
You don't remember what my client Sunny Meadow was wearing that night.
No, I don't remember what he was wearing.
You don't even remember deleting photos from your phone that evening of Jessica Marks.
I think I was taking photos of the table, and no, I don't.
So there could have been photos of Jessica Marks that look completely different than the video that we saw today.
And I guess so, yeah.
But Miss Levin, you were so intoxicated that you can't recall that.
I don't remember if I deleted or what photos I deleted, no.
But you want this jury to believe that you clearly remember hearing that it was Jessica Marks that needed to be cut off?
I'm never gonna forget when she said that. So to answer your question, yeah.
Miss Levin, you actually spoke to a police officer that night at the crash site, right?
Yeah, I was actually the one that had to call 911 after it happened.
Now, Miss Levin, you weren't truthful to that police officer at that night, were you?
No, I wasn't. I was so scared. I knew we shouldn't have been drinking.
Miss Levin, you saw your best friend's car crashed below a bridge, and you told the police officer Jessica hasn't had anything to drink.
Yeah, I did.
Now, Miss Levin, the truth is that you were actually going to be the one sued today instead of my client.
Yeah, Jess's mom did say that once. She said it was my fault, and I should have stopped Jess.
But Miss Levin, now that you're testifying against my client, you're no longer at risk of being sued.
I guess not, no.
And Miss Levin, the truth is, it wasn't in college when Jessica Marks first began drinking.
No. Jess and I would go to parties in high school together. Every now and then she'd have a drink or two.
And after high school and college, you know that she continued drinking?
I mean, yeah, she.
Objection, Your Honor, improper character evidence.
Please explain, counsel.
Your Honor, opposing counsel is using Jessica Marks's prior instances to show conformity therewith that on the day of the incident, she was either acting recklessly or was showing signs of untruthfulness.
Defense counsel, your response.
Yes, Your Honor, we're not showing this to show untruthfulness or recklessness. We're actually showing this as a habit of her continuing drinking. And like we've already stipulated, we all know that she was intoxicated that night. Therefore, the fact that she drank that night is not into question about her character evidence. I'm not using it to prove that because she drank in high school, she drank in spring break of college.
Plaintiff counsel.
Yes, Your Honor, pursuant to Rule 406, showing habit, routine, or practice, the foundation for that has not been laid, and opposing counsel has not laid that foundation yet to show that Jessica Marks would drink without thinking or that it was a continued regular practice.
May I respond to that, Your Honor?
You may. Then I have to make a ruling.
Yes, Your Honor. We have established this as we're not using it to show that it was her recklessness about her drinking. Rather, she's drank for a lot of years. We established that she drank in high school, she drank in college, she drank on this trip. We've already established that she has a habit of drinking, not that she has a habit of being reckless.
I'm going to sustain the objection. I think the most appropriate information for the jury is what happened that particular night.
Your Honor, motion to strike the testimony from my witness pertaining to that question.
We'll strike the testimony of the previous question and answer.
Yes, Your Honor.
Now, Miss Levin, you know that Jessica rented a car while she was here.
Yeah, she did.
She had to use a fake ID because in California, you have to be 21 to rent a car.
I have no idea how she rented it. I assume so. Yeah.
You knew she had a fake ID?
Yeah.
While she was here with you that week, you saw her use that ID at least 8 times.
Yeah. Pretty much every time we went out.
So before going at the Sunny's rooftop, Jessica had already been successful at 8 other bars.
Yeah.
Now, let's talk about what actually happened on March the 24th. She picked you up at your dorm around 6 p.m. that night.
That's right.
She did not appear to you as though she'd been drinking.
No, she looked like Jess. She looked totally fine.
But when y'all got back to her Airbnb, there were 2 empty bottles of wine.
There were. Yeah.
But you saw no symptoms of her being intoxicated.
Yeah. She looked totally fine. I have no idea how much she drank, but she looked sober.
Miss Levin, even at Sunny's rooftop, Jessica kept telling you that she was fine.
Yeah, that's what happened at the end of the night. Before she drove, she told me she was fine.
She never admitted that she was intoxicated.
No.
She never admitted that she was drunk.
No.
She certainly wasn't walking around vomiting.
She didn't throw up. No.
Now, the truth is, in front of Sunny Meta, you never saw Jessica Marks slur her words.
I can't remember a specific time, no.
In front of Sunny Meta, you never saw Jessica's eyes look red.
Not a specific time, no.
And to be completely truthful, Miss Levin, the longest interaction between my client and Jessica Marks that night was only 30 seconds to a minute.
Yeah, that's right.
Thank you. I have nothing further.
No redirect, Your Honor. I just ask that this witness may step down.
Witness is excused.
And at this point, Your Honor, the plaintiff rests its case in chief.
Thank you. I'm just finishing typing something here. I'll be with you in 1 second. Okay. Defense counsel,
Yes, Your Honor.
you may call your witness.
The defense calls Sunny Meta to the stand.
Very well, you may proceed.
Before I begin, Miss Meta, I just want to make sure that you can hear me okay.
Yeah, I can hear you fine.
Please introduce yourself.
Hi, I'm Sunny Meta.
Miss Meta, are you currently employed?
Yeah, I'm an entrepreneur, so I'm constantly looking for new business opportunities. But I did own Sunny's rooftop bar a couple of years ago.
Miss Meta, I want to talk about the reason we're in court today, the night of March 24th, 2019. Were you working at that bar that night?
I was, yeah.
Do you remember a lot of customers being there that night?
No, the bar wasn't especially busy. I was, however, as the only server there. There were maybe 8-10 people there at a time.
I want to talk about one customer in particular, Jessica Marks. Do you know who she was?
Of course I know Jessica. She was a customer there that night.
Do you also remember the person who was with her that evening, Morgan Levin?
Yeah, Morgan Levin came into the bar with Jessica. I believe it was about 9 o'clock.
Were you actually the person that interacted with the two of them?
I I enjoy interacting with my customers, so I usually take the shift up on the rooftop where the tables are. Jessica and Miss Levin sat up there that night.
At the time, did you know how old they were?
I did not, actually. It's our policy to card people who look younger than 45. We don't know ages, so we gotta check.
Do you specifically remember what they ordered that night?
Specifically, no, I can't say I do. My memory's a little hazy. It was 2 years ago. However, I do know that they ordered 8 drinks total.
Was there ever a time that Jessica Marks seemed intoxicated to you that evening?
Intoxicated? No, she didn't look intoxicated. I'd call her buzzed or tipsy by the end of the night, but I've been serving people for years now. Seen a lot of intoxicated people. Jessica wasn't one of them.
I'd like to show you a video that's already been entered into evidence as Exhibit 10. May the record reflect I'm showing that on the screen now. And Ms. Nonamacher, could you play that video for us?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Mehta, is that the same individual that you're telling us did not appear to be intoxicated to you?
Physically, that's Jessica Marks. But appearance-wise, that's not the woman I served that night, the woman I interacted with. If I had seen her looking like that, I would have cut her off.
Now, let's turn to her friend, Morgan Levin. Did she seem intoxicated to you?
Morgan Levin? Yeah, I'd definitely call her buzzed, more intoxicated than Jessica, actually.
Were you here in court when Morgan Levin testified today?
I was.
Did you hear her talk about an incident involving Jessica falling down the stairs?
I did hear that.
Do you recall that ever happening that night?
I wasn't quite sure what Miss Levin was talking about. I watched Jessica walk down the stairs one time that evening as she was exiting the bar. I didn't see her fall, nor did I catch her.
So did you make a statement to anyone that Jessica needed to be cut off?
Definitely didn't tell anybody that she should be cut off. Jessica wasn't drunk. Look, it's our policy to cut people off when they become drunk. Jessica didn't fit that criteria.
Were you concerned about Morgan Levin's driving that night?
Morgan Levin was a different matter. I was, in fact, a little concerned about her. I mentioned it to Jessica.
What did Jessica say when you mentioned that?
Well, I was serving their table and saw how Morgan was behaving. So I turned to Jessica and I was like, I sure hope this one's not driving. Jessica assured me that she would be the one driving home. She looked perfectly fine to do so, so I didn't have any worries at that time.
Thank you, Ms. Mehta. I have nothing further.
Cross-examination, Your Honor.
Give me 1 second. Counselor may proceed with your cross-exam.
Yes, Your Honor. Now, Ms. Mehta, during your direct examination, you called Jessica Marks sober, didn't you?
I don't recall calling her sober.
You said that she did not look intoxicated to you.
That's what I said. Not intoxicated, buzzed, or tipsy.
So let's make sense of that. You served Jessica and Morgan that night, right?
I did.
And what we have on the screen here is Exhibit 17. You recognize this as Morgan's receipt from that night, don't you?
I do.
It hasn't been changed or modified in any way, has it?
Not that I can see.
And right up at the top, it says Sunny's Rooftop Bar, doesn't it?
It does.
Your Honor, the plaintiff moves to enter Exhibit 17 into evidence.
Counsel, is there any objection?
No, Your Honor.
Now on this,
Great. The exhibit is received.
yes, Your Honor. Now, Ms. Mehta, on this receipt, you served Jessica Marks a bottle of Decoy Red Blend, right?
That's what the receipt says, yes.
3 White Claws, isn't that right?
Yes.
2 draft beers, right?
Yes.
And 2 shots, right?
That's what it says.
And you're aware that Jessica's blood alcohol content by the end of the night was at a 0.16, don't you?
I was made aware of that fact after I heard she had passed away.
And you know that 0.16 is 2 times the legal limit, isn't it?
Yeah, I'm aware of the legal limit. I've had extensive training.
What we're displaying here now is what has been pre-admitted as Exhibit 22. This is the autopsy report, correct?
It's what it says it is.
And on this, it says that Jessica's height is about 5 feet, right?
That's correct.
And her weight is 115 pounds, isn't that right?
That's also correct.
So let me get this straight. Jessica had a blood alcohol content, double the legal limit, right?
Objection asked and answered.
Response, Your Honor?
I'll allow it. Overruled.
Jessica had a blood alcohol content, double the legal limit, correct?
The legal limit for driving.
You personally served her multiple alcoholic drinks, right?
I did.
And she was 5 feet 11 pounds on the day of the incident, wasn't she?
It's what the autopsy report says.
Thank you, Mr. Rose. And it's still your testimony here today that Jessica Marks didn't look intoxicated?
Look, everybody holds their liquor differently. The Jessica I saw didn't appear intoxicated.
But that's not what you told Officer Gaskins, right?
I believe it is what I told Officer Gaskins.
What Mr. Rose now has on the screen here is Exhibit 23, which has been pre-admitted. And Ms. Mehta, I want you to follow along in your head as I read aloud. Jessica Marks was a typical buzzed girl. I read that correctly, didn't I?
You did.
Thank you, Mr. Rose. Now, before I get into that, I want to talk about what buzzed means to you, because that's how you describe Jessica Marks. You remember serving Jessica's friend Morgan, right?
I do.
Now, let's talk about how Morgan looked to you that night. Morgan's eyes were bloodshot, weren't they?
That sounds about consistent with what I remember.
Her speech was slurred, wasn't it?
Excuse me, we're talking about Morgan Levin. I heard you correctly there, didn't I?
Yes, I'm talking about Morgan Levin. You
Okay.
described Morgan Levin as having bloodshot eyes and slurred speech, right?
Yeah, I'd say it's about right.
And she was also stumbling that night, wasn't she?
Can't be sure about stumbling. It was a while ago. I definitely recall thinking that she was on her way to becoming intoxicated, for sure.
Redirecting you back to my question, Morgan Levin was stumbling that night, yes or no?
Really can't say for certain.
Do you remember making a deposition before this trial,
I do.
Ms. Mehta? Your Honor, we'd now like to display Sunny Mehta's deposition. We'd like to direct the court's attention to page 35, line 22. We apologize for any technical difficulties, Your Honor.
That's all right. Timekeeper, you should hold the time up here for a second while they're solving this problem.
Yes, Your Honor.
I believe my second chair is present.
If you'd like, I have a copy of my deposition that I can refer to.
Okay, that would be perfect.
Unneeded. Apologies, Your Honor.
Okay, we'll resume timekeeping.
Now I want to direct the court's attention to page 33, line 9 of this witness's deposition. And Ms. Mehta, I want you to read in your head as I read aloud. And Morgan's eyes got a little bloodshot. I think Morgan might have tripped over Morgan's words once. I read that correctly, didn't I?
Looks to be right.
And when Morgan was leaving, she was stumbling down the stairs, wasn't she?
I'm not sure I see that line. Could you
That is
tell me where I'm
page
looking?
34. Page 34.
Yeah,
Line.
a little stumbly. I see.
Yeah.
She appeared to be off balance to me.
So she was stumbling, right?
Stumbly, off balance.
So your words are stumbling, isn't that true?
You could say that.
And to be clear, you never cut Morgan off that night, did you?
I didn't. She hadn't reached the threshold of intoxication that we look for when cutting people off.
Even with these signs?
Yes,
And you called Morgan buzzed, didn't you?
I did.
This is what buzzed looks to you, right, Miss Mehta?
Yeah, that would appear buzzed. I mean, it's not a cookie cutter. Buzzed can mean a bunch of different things.
Redirecting you back to my question, you called Morgan Levin buzzed, right?
I did.
And this is how you described her as buzzed, right?
Those were the signs she showed of being buzzed.
And that's the same word you used to describe Jessica Marks the night she died. Isn't that right?
That's true. But like I said earlier, buzzed can mean a lot of different things. It's a broad term.
Redirecting you back to my question, you called Jessica Marks buzzed the night she died, right?
Yes.
No further questions, Your Honor.
Counsel, redirect.
Yes, Your Honor. Miss Mehta, as a bar owner, did you have any specialized training on noticing signs of impairment?
I did. It's mandated in the state of California that every bar owner and employee has to take the responsible beverage service exam, as well as the training accompanying it.
And what were the signs of impairment that you'd been trained to look for?
Well, we look for what you can see and what you can hear in a person. So what you can see includes watery eyes, a vacant gaze, loss of balance. What you can hear could be slurred speech, loud speech. It's criteria like that.
Did you see any of those signs in Jessica Marks on March 24th, 2019?
No signs like that, no.
Thank you. I have nothing further.
Is there recross?
No recross needed, Your Honor.
Very well. The witness is excused. It's now time for closings. We normally don't take a break before. Yes, counsel?
Your Honor, prior to proceeding, pursuant to the evidentiary rules, may I read 2 excerpts from evidence that's already been admitted into evidence?
Okay, we haven't really formally closed the defense case, so we'll allow you to do that if you have time remaining. Timekeeper, is there time remaining for defense counsel?
Yes, Your Honor. Defense counsel has 3 minutes remaining.
Very well, defense counsel, you may proceed.
Yes, Your Honor. May the record reflect that I'm going to show Exhibit 23, the accident report of that night. I asked Levin how many drinks Levin and Jessica had.
Objection, Your Honor. I don't believe anywhere in our competition rules is an attorney allowed to testify on behalf of a witness or present testimony in trial. I believe opposing counsel can use this in her closing argument since this has already been admitted into evidence, but testifying on behalf of her witness or on behalf of any witness is not allowed.
Counsel, your response?
Yes, Your Honor, we are allowed to use our allotted time as such, that dealing with cross, direct examination, as I have 3 minutes or 3.5 minutes left, I'm going to read evidence that's already been pre-admitted and agreed to upon both sides.
Response, Your Honor.
Yes, counsel.
Opposing counsel just said that this time is allotted for direct examination and cross-examination. There's no witness currently on the stand right now, and opposing counsel already asked her witness to step down. Therefore, she can read this evidence into her closing argument, but cannot testify on behalf of any witness or testify for any witness or under any exhibit like this.
May I respond, Your Honor?
Yes, you may.
Your Honor, I'm not testifying. These are all evidence that the jury's going to have in the deliberation room. They're going to have it when they go and make a verdict. I'm simply reading this for them aloud in my case in chief.
I'm going to allow it. Do make it clear you're not talking about a witness statement. You're talking about the police report. This is the police report, right?
Yes, Your Honor.
So you may proceed. I assume you're just going to work with the portion that's highlighted in yellow.
Yes, Your Honor. And then we will also bring in a third party's testimony after the police report.
Okay, go ahead.
I asked Levin how many drinks Levin and Jessica had at Sunny's. Levin said Levin and Jessica had not had any drinks as they were not 21. I explained that we'd likely take a blood sample from Mark's and would know if Levin was lying. I explained that I would obtain their bar tab, which I later did and incorporated by reference herein as Exhibit 17. And then this is a third party's witness testimony who could not be here under the 804 FREA subsection A rule. This is Stevie Rager.
Objection, Your Honor. This is still hearsay. May I be heard, Your Honor?
You may be heard.
Your Honor, pursuant to Rule 804, there's actually two sections that must be, two prongs that must be fulfilled in order for evidence to be an exception to hearsay. 804A has been established and stipulated by both sides, but not 804B, which concerns to those exceptions based on a declarant unavailable.
And what is that? Again, please explain what specifically you mean.
Your Honor, 804A refers to the conditions of an unavailable witness. Both sides have agreed that this witness is unavailable, and we agree to that. But Rule 804B concerns the actual exceptions if a witness is unavailable. And those, the foundation for those exceptions has not been laid.
And what is that exception, and in what respect is the foundation lacking?
There's different exceptions. There's 1, 2, there's prior witnesses sworn statement, statements made under the thought of imminent death. Opposing counsel hasn't laid foundation for any of the exceptions under Rule 804B. They only need one, but they haven't.
Your Honor, may I respond?
You may.
This is a sworn statement given at a deposition where both sides were able to cross-examine this witness and direct them, ask them questions. It's a sworn deposition and it falls under the statement.
I'm not sure either of you covering the issues involved. This is a witness is unavailable, and I believe the issue of unavailability is what's involved here, right?
Yes, Your Honor, that the exceptions are met, and the exception that it was a sworn statement in a deposition where both sides were able to cross-examine this witness means it falls under that exception.
Your Honor, I'd like to add an objection, actually, as this is cumulative evidence. If these exhibits have been pre-admitted, then the jury already has access to them. We don't need to waste the jury's time pursuant to Rule 403 for opposing counsel to read off these exhibits.
Well, this is not an admitted exhibit, is it?
No, Your Honor, it's already been authenticated by both sides. It's a sworn deposition, which is why we are reading it right now.
I'll tell you what, we'll split this issue. I was fine with you reading this item from the police report, but I think there's a real issue about this deposition and how you brought it up at this time. So I'm going to sustain the objection to using this affidavit or this deposition at this time.
Yes, Your Honor. With that, the defense rests its case in chief.
Very well. Do we need to take a break? Does anybody need a break before we go to closing statements, or are we ready to go to closing statements? We don't normally take a break at this time, but does anybody need a break?
The defense is ready to proceed.
The plaintiff is ready to proceed, Your Honor.
Very well, let's go to speaker view. Counsel, you may proceed with your closing.
May it please the court, Your Honor, opposing counsel, and members of the jury. The life of Jessica Marks was worth $149.58. With every beer, every wine, every White Claw, with every drink, the defendant pocketed more and more money. The life of this 19-year-old girl was worth $149.58. The body of Jessica Marks, of this 19-year-old girl that was found in a ditch, was worth $149.58 to Sunny's Rooftop Bar. They kept serving those drinks even though all the signs were there. Members of the jury, as the plaintiff today, when we brought forth the claim of wrongful death, we took upon ourselves a burden of proof to prove our case by a preponderance of the evidence. All we had to do was just show you that it was more likely than not that the defendant is responsible for the death of Jessica Marks. We had to prove that the defendant served alcohol to Jessica Marks, a minor, that Jessica Marks was obviously intoxicated when the defendant did so, and that the defendant was the substantial cause of her death. Like I said during my opening statement, you don't have to worry about element 1, just focus on 2 and 3. So for the second element, you heard today from both sides that the defendant, Cindy Mehta, saw the signs of someone being obviously intoxicated. The defendant tried to say that Jessica Marks didn't look intoxicated, but members of the jury, we went through those signs. And since the defendant continued to serve her after seeing those signs, you heard Morgan Levin come up here and say that when they did that, Jessica like herself. When she wheeled her car, she wasn't Jessica anymore. She lost her sense of reasoning. We proved all the elements here today. But let's go through those signs I told you to look out for in the beginning of this trial. Now, I told you to look out for bloodshot eyes, slurred speech, and stumbling. These were the signs that Morgan Levin saw Jessica Marks exhibiting on the day of the incident. And these are the same signs that Morgan Levin, that Sandy Mehta saw Morgan Levin exhibiting, but kept serving her anyway. Opposing counsel in the beginning of this trial in their opening statement said that Sandy Mehta was a responsible bar owner. And Morgan Levin, why would they cut Morgan off? He's responsible to me. And members of the jury, they called Morgan Levin buzzed. They also called Jessica Marks buzzed. Members of the jury, the signs are all there. It's clear that for Sandy Mehta, buzzed means intoxicated. During their redirect examination, that they were specifically trained to look for things that they could see and they could hear. Members of the jury, they saw the bloodshot eyes. They saw the stumbling, and they heard the slurred speech. When Sandy took the stand today during cross-examination, she couldn't get her story straight. She said that she didn't see Morgan Levin stumbling down the stairs. When she had her deposition in front of her, she still tried to fight it by saying she was stumbly. Members of the jury, that's the same thing. Clearly, buzzed to Sandy Mehta means intoxicated, specifically, obviously intoxicated, which is what you have to look for as the members of the jury. Now, when opposing counsel came here during their opening statement, they said that it was all Jessica Marks' fault. Well, the second that they brought up the issue of that, they admitted to bringing in comparative fault, and now they have the burden of proof. They have the burden, I'm sorry, Mr. Rose. They have the burden to prove by a preponderance of the evidence that it was Jessica Marks's actions that caused her death instead of Sunny's bar. But what evidence did they bring for that? We told you today that as soon as the defendant served Jessica Marks drinks and kept serving her those drinks, her decisions weren't hers anymore. So the decision she made after the defendant served her while she was obviously intoxicated were not her decisions. She was not making rational decisions at that point. And that is how the defendant caused the death of Jessica Marks on March 24th, 2019. Find the defendant liable. Thank you. I reserve the rest of my time for rebuttal.
Thank you, counsel. Defense counsel, if you'd come on screen and deliver your closing.
Yes, Your Honor. May it please the court, counsel, members of the jury. Sunny's rooftop bar couldn't stop what they couldn't see. And they couldn't see what Jessica Marks hid. The evidence today has shown Jessica Marks was successful at hiding things. She hid her drinking in high school from her parents. She successfully lied to 8 other bartenders before she ever stepped foot into Sunny's rooftop bar. She hid her real age from the rental car company in California. So when Jessica Marks showed up and sat at table 4 of Sunny's, she had gotten pretty good at hiding things. And Sunny Mehta cannot be held responsible for the things she didn't see. Now, it's the plaintiff that has sued Sunny's rooftop bar for the wrongful death. That means that it's their job to prove to you, by the greater weight of the evidence, that my client knew Jessica Marks was obviously intoxicated and kept serving her alcohol anyways. So what evidence did they bring you? 1 receipt, 1 video, and just 1 witness. So let's talk about each of them. They showed you a receipt with several alcoholic drinks on it. But what that receipt couldn't show us is who drank what. From what we heard today, it seemed like Morgan Levin was really the intoxicated one. But it wasn't just alcoholic drinks that my client served. She kept refilling water, guacs, and chips. You saw that on the receipt. So wasn't it reasonable for Sunny Mehta to think, based on the way that the two were acting, that Jessica Marks was really the designated driver that night? Isn't that reasonable? And the video that they kept showing you. You heard Sunny Mehta say that she never saw Jessica Marks act that way on March the 24th. Is it really surprising that what Jessica Marks chose to post on her social media was something she was capable of hiding from a stranger standing in front of her for just a few seconds? So although the plaintiff wants you to believe that that video shows the way Jessica acted that night, the evidence shows something completely different. You heard Jessica Marks showed no signs of intoxication when Sunny Mehta was near her. You heard that she had training in alcohol safety. She completed courses. She had a liquor license. So that video doesn't show you how Jessica Marks acted on that night in front of Sunny Mehta. It just shows you what she wanted her social media friends to see. So we're left with Morgan Levin, the only witness that the plaintiff brought in here today. She claimed that Jessica Marks acted drunk that night, but she's the one that let Jessica get into her car. Ask yourself, if she had truly believed that Jessica was so intoxicated that night, why would she let her best friend drive? If she thought Jessica looked or acted too drunk, that she was in danger, wouldn't she have taken her keys? Wouldn't she have done whatever was necessary to prevent her from driving? Wouldn't she have put her in that Uber that she already had? But Morgan Levin didn't stop her best friend from driving that night, because Jessica successfully hid how drunk she was. So how could it have been so obvious to Sunny Meta, a complete stranger, when it wasn't even obvious to Morgan Levin, her best friend? So why did Morgan Levin testify that it was obvious that night? Well, there's a couple reasons that would be her story today. Remember, she was the first one in danger of being sued over this tragedy. Had she not testified against my client today, she would have been the one in that defendant's seat. But what she told you today is untrustworthy. How do we know that? Morgan Levin had wine, beer, shots of hard liquor. She was actually the one too drunk for Sunny Meta to let her drive home. And let's not forget that as she watched her best friend's car flipped upside down below, she stood face to face lying to law enforcement. Remember, she told them Jessica had nothing to drink that night. We know that's not true. So if she had no trouble lying to law enforcement, how can you truly trust anything she told you today? Is that really what the plaintiff thinks is the greater weight of the evidence? Where's one witness from that bar full of people that came in here and told you that Sunny Meta saw red eyes, heard slurred speech, saw any indications about Jessica's intoxication at all? There wasn't even one. Now, Jessica Marks' death is an absolute tragedy. And it's not easy to sit up here today and point out to you that it was her choices that caused her death. But that's what the facts and the evidence have clearly shown. She chose to hide her age from Sunny Meta, or she wouldn't have gotten even one drop of alcohol at all that evening. She chose to hide the effects the alcohol had on her. And that's what prevented Sunny Meta from seeing how drunk she really was. Her death is not because of anything Sunny Meta or any bar employee did or failed to do. That's why the only just verdict today is finding Sunny's rooftop not liable. Thank you.
Rebuttal, Your Honor.
I'm sorry, counsel.
Rebuttal, may I
Yes,
proceed?
yes. How much time do you have for rebuttal?
I'm not sure. May I ask the timekeepers for how much time I have remaining?
Yes, you have 1 minute and 45 seconds.
Very well, counsel, your rebuttal.
Yes, Your Honor. May it please the court. When opposing counsel just came up here and said that Jessica Marks hid her symptoms of intoxication, clearly she didn't do a good job, because here today it said that she saw all the symptoms of Jessica being vexed. Well, either Sunny Meta was lying in the face of law enforcement, she was lying on the stand today when she said Jessica didn't look intoxicated at all the night of the incident. Members of the jury, all the signs were there. When Sunny Meta called Jessica Marks buzzed, she clearly meant Jessica looked obviously intoxicated because all the signs were there. And you kept track of those signs, and you'll see those signs again in your jury instructions. And members of the jury, the defense also has a burden of proof to show by a preponderance of the evidence that Jessica Marks's actions led to her death, and they didn't do that. They just called her actions before the incident, not the car wreck. Members of the jury, you have to find Sunny's rooftop bar liable and responsible for the death of Jessica Marks on March 24th of 2019. Thank you.
Thank you, counsel. That concludes the trial. We'll switch to gallery view. I'd ask all of the 4 of the participants to come on screen so we can once again associate